Next time we will be on holiday.
Yes. Yes. Okay. So I will switch off my microphone for a while, but I will be here.
Okay.
Just one thing to do before.
Hi, everyone. I think there are all of us, and we can start. So good morning to all of you, and welcome to today's Open Scientific Seminar. My name is Agata Kosieradzka, and I have one technical information that Professor Gábor Hulkó will not be online with us today, so I will screen the video he has prepared for us in the time allotted to him. So now I turn the floor over to the team leader.
Meaning me. Yes. Good afternoon to all of you once again. And as I look at the list, I realize that there are a couple of participants. I can see my Hungarian colleague Kitti Pollák. I see Agata Federczyk from Poland. We heard about Gábor Hulkó, who will be present by a video, and I see that Przemysław Ostojski is also present, but I cannot see his camera, cannot see his face. Are you here, Professor Ostojski? I'm not very convenient with this quick meeting system.
Yes, and can you hear me now?
Yes.
Yes, good afternoon. I don't know why my camera doesn't work.
You maybe need a permission.
Oh, yes. Now.
Welcome again.
Pleased to meet you for the second time.
Pleased to meet you again. So this is the first online seminar for our research group. The research group's main topic is the Administrative Judiciary, the questions, contemporary questions and challenges of Administrative Judiciary. We cannot say that this topic is a hot topic, but the time is quite hot, the weather is quite hot. So this is a not hot topic conference or a webinar in the hot weather. I do not want to take much of the time for introduction. I only want to point at the purpose of this meeting, the purpose of this webinar. It is to introduce our topics. It is to introduce the main questions of our research. I mainly concentrate my presentation for that direction. We will have today 5 presentations, mine, Gábor Hulkó's presentation from video, Kitti Pollák, Professor Ostojski, and Agata Federczyk. If I pronounce your name well, Agata?
Perfectly.
Perfectly, okay.
Yes.
Thank you very much. So, are there any questions from your side before I start my presentation, whether technical or concerning the content?
But I think works very well.
Okay.
Excellent. Yes.
Ladies? Okay. So I make an attempt to share my screen in order to show the structure of my short presentation. I will talk about the main reasons for an independent, or more correctly, for a separate administrative court system in Hungary, which does not exist today, and it has not existed before. But in the year 2018 and 19, there was an attempt. I'm sorry. Yes. maybe can you see my window?
Yes.
So
Excellent.
excellent. So in my short presentation, I'd like to talk about reasons and arguments for a separated Hungarian administrative court system. When I use the word system, it is not intended to imply that the allocation of court powers, the rules of court procedures, follows or followed a rational plan. So the system is only describing the structure of the administrative judiciary or administrative court system. The story of the system, or the story of a separate administrative court structure started in 1991, so more than 30 years ago, when the Hungarian Parliament, in a so-called Omnibus Act, reorganized or re-regulated the court procedures and the court powers. The Omnibus Act was a reaction for a constitutional court decision, as the new Hungarian Constitutional Court, by the end of the year 1990, declared unconstitutional that the people, the citizens, could not go to court challenging or debating the decisions of administrative authorities. So this Omnibus Act from 1991 re-regulated the Civil Procedures Act, as in many of the so-called socialist countries, like in many socialist countries, including Hungary, the administrative court procedures were regulated in the civil procedural code. It was the so-called 20th chapter of the Civil Procedure Act. It re-regulated the Administrative Procedure Act, modified the Judiciary Act, and numerous acts on different administrative law topics. And the general model introduced in 1991 was a quite long-lasting remedy model, including two levels of administrative procedure. The first level of administrative decision, administrative appeal, the second level, so-called the final level of administrative procedure, and 2+1, meaning 3 court levels. Altogether, in the general model from 1991, it included 5 levels of decision making: 2 in administrative, before the administrative authority, and 3 before the courts. The procedure following the general rules started at the local court, the upper went to the county court, and the third level was the possibility to turn to the Supreme Court. That was the original level original model in 1991. There were many changes in the system from 1991 to 2021. We could write, and I will write a long list of these changes. I found 13 significant changes in 30 years. We cannot say that it's a small number. That's quite a big number of changes. The changes affected the procedure. It became obvious in the first years that the civil court procedure is not fully sufficient, not fully good enough to administrative court procedures. The changes affected the rules of evidence, the rules of making proof, who should prove, and what should be proved in the court procedure. After the millennia, in the beginning of the 2004 and 2005, there was an attempt to re-regulate the non-contradictory procedures. And under the umbrella of this regulation of non-contradictory procedures, the Ministry of Interior made an attempt to make a separate administrative court procedure act, but there was no consensus for that separate law. There were changes in the court levels. The main change was at the beginning of the 2000 year of 2000, or a couple of years later, with the appearance of the regional courts. Regional courts cover 2 or 3 counties in Hungary. We have 20 counties, including Budapest capital, and we have 5 regional courts. And at the first step, there appear 3 regional courts, and then 2 other, including the Budapest capital regional courts. And the regional courts were built into the remedy system of administrative court procedures, making it more complicated. But soon after it, the parliament changed the rules, and appeal in administrative court procedure appeal was and became exceptional. The main remedy within the court procedure became the supervision by the Supreme Court. Besides the general model of administrative remedies, administrative procedures, a number of different procedures started their operation, started their life. So it was difficult to say how many levels of procedures we have. In general, there were 1-level administrative procedures with 2-level or 3-level court procedures, 2-level of administrative procedures, 2 levels of court procedures. So the system became quite complicated. The powers of courts were also changed by these 13 significant changes. The original model followed the quashing, the eliminating power of courts, but soon there were a number of types of cases where the court could amend to modify the challenge administrative decision. Almost half of the cases fell within these types, where the court had the powers to change, to modify. Let me give a couple of examples. In all cases concerning questions of taxation, different types of taxes, personal taxes or value-added tax, all types of tax cases, it was possible, not compulsory, but it was possible for the court to change the unlawful decision to make it lawful. And sometimes the law combined the 2 powers, the questioning and the amending power. Interesting feature was during this period that there were special administrative court powers within the Constitutional Court. Let me give one example. The decisions of the National Election Committee concerning referenda was possible to challenge in the Constitutional Court. There were years where the half of the cases of the Constitutional Court dealt with these kind of referendum cases, referendum debates, making the Constitutional Court, or partly making the Constitutional Court as a specialized administrative court in the content, of course not in the name. And it was the Constitutional Court who decided over the local government's bylaws, the local government's regulations. The 30 years, besides many changes, significant changes, remained an interesting system, interesting from a researcher's side, not from the practitioner's side, because it was an administrative, or is an administrative judiciary without administrative courts. During these major changes, there were only one step toward the wrong direction. That was the establishment of administrative and labor courts. These administrative labor courts started their operation in 2013 and finished their existence 2 years ago, 2020. They were part of the ordinary court system, so they were organized within the ordinary court system. And it is very difficult to describe them with the correct words. they were fully integrated into the ordinary court system and half separated from the court system. They were not uniform within themselves. They remained divided during their 8 years of existence, meaning that administrative and labor courts always consisted of two parts, an administrative judges part and the labor judges part. The notion for this interesting court model or interesting court type was that there were labor courts, one in the 20 counties, and the labor courts already gained during the 90s. They already gained a special character. They gained dual nature. What does that mean? That meant that the labor courts heard labor law disputes between the employee and the employer. And they also heard disputes between citizens and the state, social security debates, and the debates concerning the decisions of the labor authorities went to that labor court. So the lawmaker, the parliament, decided that this dual nature of the labor court is a solid ground for an administrative and labor court, making a step towards separate court system. But that was not a successful model. It was not a successful type of the court. Why? Because they remain divided within themselves. Administrative law judges remained administrative law judges, and the labor law judges remained labor law judges. It was very rare to see judges with double character. Our administrative judiciary without administrative judges can be traced by the fact that in Hungary there are no administrative appointment to administrative judges position. Judges are judges with general character. We are appointed to the judiciary, we are appointed to a court, and there is only an assignment which is necessary to hear administrative cases, but this is not an appointment for administrative judge. The assignment is not goes not only to administrative cases. As a judge, you need an assignment to hear labor law cases, to hear juvenile cases, and it is necessary to hear cases in the Curia, in the Supreme Court, of local government regulation cases. The judge's career is quite mixed. The picture of judge's career is quite mixed. It means that coming from the public administration is accidental, is not planned. It means that to become an assigned administrative judge in the judiciary is not a career step of a lawyer within the public administration. It is outside the public administrative lawyer career. And we also have to know that until 2018, we had no separate administrative court procedure law. We were part of the Civil Procedure Act, and only during the reform generated by the State Reform Committee and the Ministry of Justice was a new Act of Parliament, a new code for administrative court procedure enacted. We see the long-lasting effects of the socialist law in this system, which I try to summarize in short. What are these effects of socialist law? The lack of a separate administrative court system, lack of administrative judges' position, having only a kind of assignment by the president of the court for that cases, having so many changes during the 30 years. Changes in court level, changes in court powers, and emphasizing the most important, administrative judiciary or administrative cases is still seen as a part of civil procedures, as part of a civil jurisdiction of the courts, as the national, the regional, and the local statistics or reports on courts working shows only criminal and civil judiciary, and administrative judiciary is understood within the civil one. What happened in the year 2018-19? The reform already, as I mentioned, started in the State Reform Committee in 2015, where elaborations for separate administrative court procedural started, and in the planned law, in the draft law, the higher administrative court expression appeared. It was not a separate court; it was only a naming of the Budapest County Court as an important administrative law court. Important and special cases went to that court, Budapest County Court, and in order to make it simple, the draft and the finally enacted code named it with small, not with capitals, with small letters, High Administrative Court, to make the text simpler. Finally, after the enactment of that code, the President of the Republic raised a constitutional veto, saying that the High Administrative Court, the name High Administrative Court, covers a new type of a court, and the new type of court cannot be enacted in a procedural law with normal majority in the parliament. In the other constitutional system, it requires 2/3 majority by the parliament, and it requires the amendment of the Judiciary Act. The Constitutional Court gave right to the president. So the High Administrative Court expression, this name, disappeared from the final version of the code. The final version of the code entered into force in 2018, raising the hope for an independent administrative court, as after the 2018 elections, quite quick, speedy change, modification or amendment to the constitution was enacted by the parliament. It took only 10 days or 15 days in June, when the parliament modified the constitution, nominating the separate administrative courts. You can see the extract from our constitution, from Article 25. That was in force between 2018 June until 2019 December, as a most interesting example of a non-existing constitutional rule. As after the amendment, it appeared in the constitution, but following another constitutional rule, it did not enter into force. So it appeared in the constitution, but had no effect. In 2019, after the enactment of a separate Administrative Courts Act, saying that a high administrative court and 8 other administrative courts will start their operation in 2020, after starting the organization of the separate court system, after the recruitment of the personnel to that new courts, the parliament decided suddenly that it will postpone the introduction of the new system. In 2019, there were raised reactions. We all knew that the administrative judiciary is a quite sensitive topic even within the government. And what was unexpected, the negative reactions from outside from outside of the country, from the European Union, and even members of the European Union, member states of the European Union, having separate administrative court system. We have to mention the German Federal Republic having different court systems for administrative cases, and other member states and the European Union institutions of the Union itself gave negative reactions to the planned Hungarian system. We had a double dream. I mean, under the makers of the draft, of the court procedure, the makers of the draft for the separate administrative courts act. One of our dreams was to make a separate system for administrative courts, because it is the constitutional tradition of Hungary to have a separate administrative court. And the separate court was abolished by the communists in 1949. And it's high time to reinstate this separate court. The other dream was a theoretical or professor's dream. Dream was to eliminate the weaknesses, the eliminate of problems of the existing system, to make it systematic, make it rational in almost all elements concerning the levels, the procedure, the court powers, and the recruitment of the personnel, recruitment of the judges themselves. So after these negative reactions from member states, from important member states, and from the European Union itself, the Parliament decided to postpone. And by the end of 2019, even the fundamental law, even the Constitution of Hungary was changed, and the Separate Administrative Court Act never entered into force. The questions, or the main question concerning this history, is why. And my main purpose is during this Polish-Hungarian research project is to examine the whys, examine the reasons, the main and the real reasons to postpone and finally to delay the reform for Separate Administrative Courts Act, and to examine these reactions, to examine these criticism. Was it real and fact-based, or were these criticized only motivated by political reasons? So that would be the end of my presentation, which was not that short that I anticipated. Therefore, I do apologize to all of you, and giving back the floor to you for questions.
Thank you.
Any questions? No
It's
questions.
very interesting problem, though. So we'll continue next time to listen to you.
Okay.
Yes.
Then I give the floor to my Hungarian colleague Kitti Pollák.
Thank you. I will start sharing my screen. Just one moment.
Okay.
I don't know it's why failing it. Sorry. It's do you see my screen? I think no.
Not yet. Not yet.
I'm trying my best. It's right that someone is sharing. I think it's I am sorry, I'm not arriving to share my screen. I don't know if I can send to Agata or to Conrad to try to share it. It's right that it's
Yeah. You can send it to my email. So it's Agata Patyi.wrobel.
Can I send it directly to the
Yes. You can in the message.
message? It's just fails the connection if I start to share it. So I'm very sorry. I don't know why it's not working. So I send it to the PHR P2 email. I hope you got it.
Sorry, I didn't get anything.
Okay, I think it just went. Okay.
Maybe we can change to Gábor Hulkó's video if it is possible, and we see his presentation. We follow his short video, and during this time you can fix the problem with the screen sharing. Is it possible to ask for the Gábor's video, Kitti or Agata?
Yeah, I'm trying to share it. Can you see that?
Yes.
Yes.
Okay.
Okay.
Dear colleagues, dear friends.
And do you hear something?
Yes.
Okay.
First,
So we can start by the. Oh, okay.
dear colleagues, dear friends. First and foremost, today's workshop live. I will try to join the workshop for sure online, but I cannot make any promises, for this is as it depends on circumstances beyond my reach. So I'm sending you this recorded presentation and wishing you pleasant and fruitful work. For today's topic, I have prepared a short presentation on the judicial activism of the Court of Justice of the European Union, which I will refer to as the Court. My presentation is divided into three structural parts: a general overview, the identification of the phenomenon through a concrete example, and some considerations of the possible conclusions. In accordance with this, the first question to be examined is the activities of the Court. As it is known, the main functions of the Court of Justice of the European Union are ensuring EU law is interpreted and applied the same in every EU country, and ensuring countries and EU institutions abide by EU law. A case can be referred to the court under different types of procedures laid down in the treaties. These are infringement proceedings, actions for annulment, actions for failure to act, actions for damages, and preliminary rulings. As to infringement procedures, typically the Commission can open an infringement proceedings against a member state if it considers that it has failed to fulfill an obligation under the treaties. Before a case is referred to the court, the Commission delivers a reasoned opinion on the case after giving the member state concerned the opportunity to submit its observations. If the member state concerned does not comply with the opinion with the time limits set by the Commission may refer the matter to the court. This possibility is not only open to the Commission, but also to the member states, which may refer a matter to the court if they consider that another member state has failed to fulfill an obligation under the treaties. However, there is still a stage of procedure before the Commission, since before a member state can bring an action against another member state, it must refer the matter to the Commission, which, after giving the parties opportunity to make their own views, delivers an opinion, and if the member state does not comply with the opinion, the matter can be referred to the court. If the court finds that a member state has failed to fulfill an obligation under the treaties, that member state must take the necessary measures to comply with the court's judgment. Action for annulment. In the annulment procedure, the court reviews the legality of binding rules of EU bodies. Accordingly, it examines the legality of legislative acts and other acts of EU bodies, except for recommendations and opinions, as well as some acts of the European Parliament. The court shall also examine the legality of acts adopted by bodies, offices, or agencies of the Union, which produce legal effects vis-à-vis third parties. Any member state, the European Parliament, the Council, or the Commission may initiate proceedings. An action may be brought for lack of competence, infringement of essential procedural requirements, infringement of the treaties or of any rule of law relating to their application, or misuse of powers. In addition, any natural or legal person may, under the conditions set out above, bring an action against an act addressed to that person or affecting him directly and individually. If the court finds that the action is well-founded, it will declare the contested act null and void. Action for failure to act. An action for failure to act can also be brought against EU bodies if one of them fails to act in the breach of the treaties. To start proceedings, member states and other institutions of the Union can bring an action before the court to have the infringement established. Actions for damages. Actions for damages mean sanctioning EU institutions. Any person or company who has had their interests harmed as a result of the action or initiation of the EU or its staff can take action against them through the court. And lastly but not least, which is probably the most important case of the current study, taking a preliminary decision. A request for a preliminary ruling may be made to the court if a question concerning the interpretation of the treaties and or the validity and interpretation of acts of the EU institution, bodies, offices, or agencies arises in proceedings before a national court or tribunal in order to rule on the underlying case. If such question arises before a court in a member state, that court considers that it is necessary to rule on this preliminary question in order to give judgment, it may ask the Court of Justice of the European Union to rule on the question. To sum it up, the court has no power to invalidate a national rule in any procedure and has no legislative function. However, through its decision-making procedure, decisions and legal interpretation are able to influence the rules of interpretation or even the legal system in the selected member state. The Court of Justice of the European Union has interpretative powers with regard to EU rules. Although the Union does not, strictly speaking, have a constitution, the treaties can be considered a quasi-constitution, which lay down the main principles on which the Union operates and values and the objectives it seeks to achieve. The court has exclusive competence to interpret the treaties and accordingly performs a quasi-constitutional court function within the Union. However, the treaties are not complex legal texts in the sense that in many cases they only set out basic objectives without laying down specific and detailed rules. As a consequence, their provisions must be given specific content by legislation or by interpretation of the law. If the latter, interpretation of the law by the court, is considered to be overly extensive, at least in the view of the member states, this phenomenon can be described as judicial activism. This has both positive and negative effects. On the positive side, an extensive interpretation has often contributed to the development of EU law and has encouraged the EU legislator to codify the interpretation of the court by means of legislation. for example, in the field of social rights or internal market regulation in many cases. The negative consequence of the judicial activism is that it can impose obligations on the member states and extend the scope of EU law to powers that have not been transferred by member states. No judicial activism explicitly entails the invalidation or inapplicability of a national rule. In proceedings before the court, national law is taken into account as a fact, and it is in the light of this fact that the court interprets EU law. But the inapplicability of a given national rule can only be declared by the national court only in the light of the court's judgment. In the national court proceeding related to the case in question. A case of this activity can be observed on a concrete case of value-added tax issue in the Czech Republic. It is the case of EP Energy Trading as the applicant. The applicant submitted its value-added tax returns for the tax assessment periods of August, September, November, and December 2015, in which it claimed an overpayment of tax amounting approximately to 126 million Czech crowns, it's about 5 million euros. The tax authority initiated a tax audit of the applicant for all 4 tax assessment periods in turn before the tax was returned. On the basis of the result of the tax audit, the tax authority issued payment orders in which it granted the applicant the full amount of over-deductions as claimed by the applicant in its tax return. The tax authority awarded the applicant interest on the tax deductions at the rate of 1.05% per annum. The applicant appealed against this decision and argued that the 1.05% applies to a different audit proceeding, and according to the general rules, the taxpayer is entitled to interest on the refundable overpayment at the rate of 14% plus the Czech National Bank base rate. Furthermore, the tax authority's activity is also contrary to the requirements of EU law, namely Article 183 of the Value-Added Tax Directive. According to the applicant, the fixed interest rate is disproportionately low. The starting date of the interest is based impermissibly on the commencement of the control procedure and not on an objectively determined date, and the provision of the Czech tax code makes it impermissible distinction between different control procedures. Enough to say that the case was brought before the Czech Supreme Administrative Court, which ruled that in the context of the assessment of interest, it is irrelevant what tax proceedings are involved, only that the tax authority has withheld the taxpayer's financial assets. There is no difference in the entitlement to interest on the deduction withheld between a situation where the delay in payment was caused due to the initiation of a procedure to resolve doubts or to the initiation of other tax audit procedure prior to the assessment of the tax. The administrative court's argumentation was based on the interpretation of Court of Justice of the European Union, according to which Article 183 of the Value-Added Tax Directive states that if the amount of the deduction in a given tax period exceeds the amount of tax due, member states may either carry forward the excess amount of the deduction to the following period or refund the tax under conditions they determine. It is clear from the case law of the court that the member states undoubtedly have a degree of autonomy in determining the conditions under which they pay or carry forward the excess deduction incurred. This does not mean, however, that the conditions set by the member states for the repayment of excess value-added tax deductions cannot be reviewed under EU law. Member states' autonomy is limited in particular by principles of equivalence, effectiveness, and fiscal neutrality. To put simply, the principle of equivalence requires equal treatment for breaches of EU law and national law. The principle of effectiveness prohibits member states from making it impossible or excessively difficult to exercise the rights conferred by EU law. A further fundamental principle of the common watch system is the principle of neutrality, whereby the tax is levied in the most general way possible and where its scope covers all stages of production, supply, and services. In particular, where the amount of input tax exceeds the amount of output tax, the taxable person is entitled to deduction for the excess. In the view of the Supreme Administrative Court, the duration of the taxpayer's entitlement to interest was not determined in a clear and objective manner, and in opposition to the principles of equivalence, effectiveness, and neutrality. The tax authority's procedure was therefore contrary to the Value-Added Tax Directive and the case law of the court. As to the interest rate, it was said by the Administrative Court that the base rate set by the Czech National Bank plus 1 percentage point. However, the Supreme Administrative Court declared that the procedure of calculating the lump sum of the interest does not comply with the previous judgment of the court, and that the current regulation is contrary to the Article 183 of the Value-Added Tax Directive in this regard. But in the final effect, the interest rate was set to 1.05% as the tax authority declared in the beginning. Furthermore, it is interesting to point out that the Czech legislator was also aware of this problem with the application of this provision, having amended the section of the statute in question several times in the meantime. In this particular case, the Czech legislator's reaction was, as the Supreme Administrative Court of the Czech Republic itself pointed out in its judgment, to amend the relevant provisions of the Czech tax code, that is to change domestic law in a way that conformed the court's interpretation of the law. As for considerations and final thoughts, it was shown in the particular case of the basic problem with judicial activism is that in practice a solution almost always lies with the national legislator to amend the problematic national sources of law. This is not a systemic solution and cannot be considered a general or good practice from a long-term point of view, not to mention its ex post effect. Such cases could lead also to the coexistence of two parallel interpretations of the law in individual cases with similar factual situation. One where the authorities act only within the framework of national law, and another where a different legal interpretation is established on the basis of judicial interpretation based on the EU law. The question of avoiding parallels opens up a number of wider problems and issues. One of these is the fundamental question of the relationship between EU law and national constitutions, which has not been satisfactorily resolved yet. It is not for the courts or national authorities to resolve this relationship, but it is the public bodies that are confronted with this problem. It is therefore necessary, first and foremost, to clarify the system of sources of law at EU and national levels, which would serve as a guide for the functioning of the courts. Beyond this formal approach, the relationship between EU and national constitutions is also a question of substance, as there may be issues of principle and socio-political issues like traditional family concept, rights of minorities, the role of Christian tradition, child protection, to name some, which may have different approaches within each member state. I'm convinced that if the EU as an international entity wishes to take a stand on value issues, it would be unfortunate if the court could be used as a tool to do so. In the light of these reasons, I therefore believe that even if there may be small questions in particular cases, a closer examination of the court's judicial activism, both from a theoretical and a legal point of view, is necessary to assess its spillover effects. Thank you very much for your kind attention.
And I already have the presentation of Mrs. Professor Pollák, Kitti, so we can try to display it again.
Kitti, microphone is needed for make
Yes,
yourself
I'm
heard.
just. I hope you're hearing me now. I have the internet connection, I think, and that's why it's a bit slower, my sharings.
Go ahead.
Okay.
Okay.
So good afternoon. Thank you very much for Agata for sharing my presentation. My name is Kitti Pollák, and in the Polish-Hungarian Research 2022, my researches will focus on two aspects, of course, related to each other. First, my research presentations in the next 2 months will examine few aspects of the regulation, mostly the novelties of the regulation of the Code of Administrative Litigation in Hungary. And secondly, my research will analyze a special judicial review procedure, the rules regarding the judicial review of electoral cases. This last topic is very actual in Hungary, as the national parliamentary election was in spring 2022. This is my overall plan for the next half year of research. But first of all, today I would like to give a short overview of the Code of Administrative Litigation. Then I would like to highlight through a case only one dilemma due to the time limit regarding the notions used in the code and the scope of this code. Without further explanation regarding the history of the codification of the court procedure rules in administrative cases, this was also mentioned in the presentation of Professor András Patyi. I would only underline that the Code of Administrative Litigation entered into force in the 1st of January 2018. Before this date, the administrative court cases, the applied procedure law in these cases was the Code of Civil Procedures. I would like to ask Agata to turn the next PPT. Thank you very much. So first of all, let's regard the structure of the new code. So we can find there is a preamble and there are 6 parts of the code. The preamble contains the reasons for the creation of the independent administrative procedure code. In part 1 of the code, it defines first the scope of the act, the responsibilities of the court, and the obligations of the party. It also describes the administrative court system and names in which type of cases which courts should act in the first instance. It also names the parties and the interested persons in the court proceeding and contains rules regarding representation of the parties. Part 2 of the code regulates the first instance procedures. So there we find rules regarding different types of statements of claim, forwarding the claim, measures based on the statement of the claim, the preparatory arrangement of the court actions, the hearing, taking and the evidence rules, etc. Part 3 is titled as decisions in the code. We find different types of court decisions, but this part also defines the limits of the court power in the decision, and also we find the legal effects of the court decisions. Part 4 of the code contains legal remedy possibilities which could be used against the judgment of the court, such as appealing against the judgment or extraordinary procedure remedy, the review procedures and the retrial procedures. This part of the code also contains rules regarding the procedure which should be followed in respect if there is a constitutional complaint. Part 5 of the code, we can find different rules of special administrative court actions and other administrative court procedures like the simplified procedure or the procedures for reviewing the conflict of local government decrees with other laws. Part 6 is closing provisions. Here we find basically the final provisions of the code, like the date of entering into force of the code. So I would like to highlight 2 points regarding the structure of the administrative litigation code. First of all, we do not find a separate chapter regarding principles in the code, but especially in chapter 1 of the first part, there are provisions of principal nature. We can find such provisions like referring to the principle of legal protection. I'm still in the other PPT presentation, but it's just the second note. So my second note that the background legislation of the Code of Administrative Litigation is the Code of Civil Procedures. The Code of Civil Procedures should be applied if it is expressly indicated in the Code of Administrative Litigation. But today, in my today's presentation, I would like to only focus in part 1 general provisions in chapter 1, and I would like to examine few aspects of the scope of the Code of Administrative Litigation. So the first rule of the Code of Administrative Litigation determines the material scope of the code. In terms of sectoral legislation, this means that the application of Code of Administrative Litigation does not need to be prescribed. So the rules of the Code of Administrative Litigation are directly applied if there is an administrative dispute. This paragraph 1, which you see in the PPT 2 Article 1, also makes it clear the scope of the Code of Administrative Litigation. That on the one hand, administrative dispute educated in administrative law suite, and in this case, we shall apply the code, and on the other hand, there are other types of administrative court proceeding in which the code should be applied. This division corresponds to the code structure, what we saw in the former PPT. So, in part 5 of the code, this is we find the special administrative and other administrative court proceedings. Keep in mind that paragraph 2 of Article 1 defines that there are some administrative legal disputes in which the Code of Administrative Litigation is not applied. This could happen either by referring to a special procedure rule or by prescribing that the procedure of a court that does not qualify as a court acting in an administrative case based by the Code of Administrative Litigation. So, for example, this is the case of reviewing the acts of infringement procedures. Article 1 should be examined with Article 4 and 5 of the Code. I would like to ask Agata to skip to the next PPT presentation. So it's very complex, as you see, when we should apply administrative litigation. So first of all, the court adjudicates in administrative disputes. The subject of the administrative dispute is defined in Article 4 of the Code. This is basically the lawfulness of an administrative act. As you can see in the PPT under number 1, it's still a very general clause, and the general concept of public administrative activity can be defined by this article. So, administrative activity has 3 conceptual elements. First of all, this administrative activity is carried out by public administrative body. The definition of public administrative body is given in the Code of Administrative Litigation. This administrative activity should be regulated by administrative law. And thirdly, the administrative activity can be active on the one hand, so this is an administrative act, but it can be also realized by omission. So when the public administrative body does not act. An essential feature should be also mentioned regarding administrative activity, that it should have a legal effect. So different types of administrative act are also listed in the code. As you see in the PPT, these are individual decisions, provisions of general effect not falling under the scope of act of legislation to be applied in individual cases. These are like public body regulation, recommendations, announcement, methodological guides of autonomous state administrative bodies and independent regulatory bodies. And of course, administrative contracts are also seen as administrative acts. Administrative contracts, the definition administrative contract is also given by the code. But Article 5 also says that courts shall adjudicate disputes for by
Kitti, there's something wrong with your voice, or with the line.
I hear someone's behind. There is I don't know. There is like ambulance going, but this is not me. I think it's Agata.
I heard the ambulance, but the voice was not clear. May I ask you to cut your presentation a little shorter, if it is possible?
Yes.
Okay.
So these are the 5 aspects when we should apply the Code of Administrative Litigation, administrative disputes of public law, which fall in the by virtue of an act under the jurisdiction of administrative court. So norm control procedures regarding municipality decrees. 4th case is disputes relating civil service legal regulation. This civil service legal regulation is defined also by the code, and there are disputes related to administrative contracts when we should apply the code, the rules of the code. I brought a case. Can I ask Agata to turn to the next slide? So this is a case study showing you that even though it seems easy to define when we should apply the Code of Administrative Litigation, in fact, there is still lots of questions. In this case, the plaintiff of this case is a mandatee, a local government representative. This local government representative asks from the court to oblige the local government to pay his remuneration defined in a municipal decree. This municipal decree is a normative act, so it's not an individual act, not an individual decision. This is normative act. The first instance administrative court decided that this is not an administrative lawsuit. So it's not administrative court who decided that in it, and it's not falling under the scope of the Code of Administrative Litigation. But the plaintiff turned to the highest court of Hungary, to the Curia, saying that this dispute is a civil service legal regulation dispute, and the Code of Administrative Litigation shall be applied. So what shall we discuss here first? That is it really this dispute is a dispute relating a civil service legal relation, or is it a dispute which was is a public dispute, public law dispute, and why there is an act which says that it should be decided under the jurisdiction of an administrative court, or is it an administrative dispute? And the highest court of Hungary, the Curia, said the following, that this is not a civil service legal relation dispute. Why? Because it does not contain essential elements of the civil service legal relation, which are, for example, that this is not an employment legal relationship, which is established for purpose of work. Persons in civil service legal relation have an employer and are considered persons employed on the behalf of the state. Their obligations, their rights are defined by special legal acts. In contrast of this civil service legal relation, the local government representative is not an employment legal relationship. The special work to be performed within it basically means that it's implementing the will of the voters. The local government representative does not have an employer. The representative body of the local government or the local government itself cannot be classified as the local government's representative employer. So the local government representative has no employment rights, no obligation, not classified in a special legal act. This is not a dispute relating to civil service legal regulation. Secondly, we should note that this is not a public dispute, and it's not a public dispute, and there is no an act, there is no an article of an act which says that this dispute is under the jurisdiction of the administrative court. So the last question, is it an administrative dispute? And the highest court of Hungary, the Kuria, said that yes, this is an administrative dispute which should be judged in an administrative lawsuit by the court using the Code of Administrative Litigation. So the representative body of the local government in application of the Code of Administrative Litigation is a public administrative body that created a municipality decree on the remuneration of the local government representatives' remuneration. It accepts individual administrative decisions in the course of fulfilling the municipality decree. As the result, if there is a failure to fulfill the obligation, this legal dispute can be classified as an administrative dispute according to the Code of Administrative Litigation. So yes, the Code of Administrative Litigation shall be applied in this case too. Thank you very much for the opportunity to present. Sorry for the problems of the presentation. Next time I will try to do better. And there are still lots of questions regarding the application of the code, definitions used in the code, and this will be presented in my next presentations and in my article too. So thank you very much.
Thank you very much, Kitti, for your presentation. And regarding request from Przemysław Ostojski, I propose a change in the agenda. Is it possible by the others that now Przemysław will start his presentation? Agata, do you accept it?
Yes, of course.
Please, Professor, the floor is yours.
Thank you very much for your understanding. I have a quite difficult situation. I received a call from my doctor that I have to go to at 16:30. So I will shorten my presentation and not to talk too long. At the beginning, thank you, and it's my great pleasure to take part this year to in this project, in my opinion, very valuable, about the reform of administrative judiciary in Poland, in Hungary especially. And last year I was talking about the, I would say, ordinary administrative courts. And this year I would like to deal with judicial review performing by ordinary courts in Poland, especially by regional court, Warsaw Regional Court, Competition and Consumers Protection Court in Warsaw, deal with antitrust decision issued by a competition authority that is excluded from administrative courts and plays big crucial role for Polish and European Union market. And I would like to verify my thesis that competition cases should be subject to the jurisdiction of administrative court. I hope to verify the right way this thesis, because there is still the question also in the literature, Polish literature, in terms of this question, and I hope to resolve it thanks my analysis during this project. So, and this time I would like to start with arguing about the case law of European Court of Human Rights that created standards in judicial review and also standards in competition cases. For the foreign people, especially outside Europe, it's tricky to talk about human rights in competition law. But it is a fact, especially with regard to judicial review. And at the outset, I should tell that in the settled case law of the European Court of Human Rights, administrative bodies may be entrusted with the adjudication of cases classified as criminal within meaning of Article 6 of the Convention, provided that they are not classic criminal cases, especially competition cases, and administrative proceedings in which fines are imposed or classified precisely as proceedings involving criminal cases in the broad conventional sense. But a prerequisite for admissibility of adjudication of such criminal cases by administrative authorities is that its decisions are subject to the subsequent judicial review. This is especially true in cases where the body is not fully independent of the political executive. And recently it was the big issue also in the European Union if the Polish competition authority is independent of the political executive. And it should be noted that the part of competition cases are also classified as civil cases in the meaning of Article 6 of the Convention. That means the cases in antitrust proceedings in merger control. In terms of the intensity of judicial review of administrative actions by the courts of the Convention's signature states, certain standards were also established by European Court of Human Rights. And the main thesis, the main conclusion derived from the case law of the European Court is that in order to comply with Article 6 of the Convention, a system in which an administrative decision is first made by an administrative body and then reviewed by a judge, the national court must exercise so-called full jurisdiction. And this term was explained inter alia in the case Lecomte, Van Leuven, and Dimer versus Belgium, where the courts stated that the judicial determination must encompass both facts and law. Nevertheless, the European Court has shown some flexibility in the wide range of cases, and it has recognized as to what constitutes the full jurisdiction. In another case, European Court stressed that judgment should be sufficient in terms of judicial review, and to determine what that means, there should be met such criteria as the subject matter of considered decision, secondly, the manner in which the decision was made, third, the content of the dispute, including the claimed and factual grounds of the appeal, and finally, the possibility of examining procedural defects. And I think the last one is the most important. Moreover, the European Court stressed that it's not allowed the situation where the national court is bound by the findings made up by a public administrative body. And the case law of the European Court, it's also noted that the legal orders of Council of Europe member states, it's not often that national courts conduct a reconsideration of administrative cases, that they substitute the administrative body's position with the court's assessment, and there exists an unlimited right to adjudicate facts. It will be important when I will continue my research, but as for now, I would like to tell also about shortly about two cases. The Polish, the first one is the Polish, and the second one is Hungarian. So in the year 2011, the court considered if the Polish model of judicial review of public administration is compatible with Article 6 of the Convention, in case Potocka and others against Poland. And in the conclusion, the European Court stated that Polish Supreme Administrative Court conforms to the standards set for a court in the meaning of the Convention. And this is because the Polish legislature has equipped this court with the power to overturn the Challenge Act in the whole or in the part if a violation of procedural fairness requirements are found. And considering the appellant's case, the Supreme Administrative Court in the Potocka and others against Poland case examined in sufficient depth, according to European Court, the issues related to the application of the provision of Article 107, subsection 3 of the Code of Administrative Procedure, regarding the obligation to provide factual and legal reasons for administrative decision. And the European Court concluded that the Polish court examined the so-called expediency aspect of the case. Thus, it found unjustified the applicant's claim that the Polish court had contented itself with examining the case strictly within the limits of legal doubts that had arisen. And in another interesting case, that means debut, I don't know if that's if I pronounce it the right way, it is Hungarian, debut versus Hungary. The European courts issued a decision in 2012 declaring that the complaint was inadmissible because the Hungarian courts had remedied in a three-instance process the collection of evidence by Hungarian competition authority. That means I would say the lack of evidences before the Hungarian competition authority were healed in the three-instance process before Hungarian courts. It is also very important when it comes to the assessment of the proceedings in which the judicial review of competition authority are conducted. Nonetheless, the most significant in the last decade was the case in Menarini Diagnosis versus Italy from 2011. And I will not talk about the whole case, but I would like to say that, summarizing that in this case, European Court stated that Italian courts or complies with Article 6 of the Convention because the Italian courts can go far beyond the review of legality of administrative decisions, checked whether the authority properly use its powers, if it can assess also the reasonableness and proportionality of the choices made by the competition authority. And even they are allowed to check the proportionality of the technical assessments made by the authority. And this is why the Italian courts conduct a full review in the meaning of the convention, and they can overturn the challenge decision and send the case back for a new decision by an impartial body. And that means that it is not required by the European Court of Human Rights that the administrative courts or other courts conducting the judicial review of administrative action can amend and change the administrative decision. It is sufficient that they have power to overturn the challenge decision. This is everything as for today. Thank you very much for your attention and the possibility to be before you, Professor Agata. And I hope we can cooperate in very good, pleasant atmosphere also in next time. Thank you very much.
Thank you very much, Professor Ostojski. Thank you, Przemysław. And now I give, without any comments, I give the floor to Professor Agata, and we are ready to listen to your presentation. The floor is yours.
Thank you. I'm fighting with my presentation. I don't know whether you can see it. Yeah.
It is okay.
Now it's okay? Great. So in case of any problems with presentation, please let me know and I will try to fix. As a first subject for my seminar, for our seminars, I chose types of participants in administrative court proceedings as a kind of introduction. It seems to be very obvious and very easy issue, but I would like to present those type of participants linked to the types of interest involved in administrative court procedure. So I would like to do such research, and I want to emphasize the aspects of interest that are protected within the Polish administrative court. And of course, such analysis requires the formulation of questions, and the basic one, the obvious one, is which types of interests do the legislator consider important to give protection from the courts? And maybe the most important, even more important question is which are not protected before the administrative court. And it is possible to establish a hierarchy of such interests in the sense that there are more important interests or maybe there are less important. And what in case of a conflict of interest? who decides, who gives the precedency, which interest is important in particular case. And the answers obtained to these questions, and of course other, will allow to determine which categories of interest have been given protection before the administrative court in Poland. And when you look at the Polish procedure before administrative court, we can distinguish three categories of entities. And first, the most common, and it is parties in dispute. It is administrative court, as the administrative court proceeding is contradictory. So we have a complaint, and we have public administration, and of course the proceeding may start only compliant, not the administrative authority. Then we have participants with the rights of a party and participants of the proceedings. And when we look at the active legal standing, so who can start the case in front of the administrative judge. So first of all, it is anyone who has a legal interest in it. This is the most big and common huge part of the situation. Then we have a public prosecutor. Then we have ombudsman and also ombudsman for children. And we have also a social organization within the scope of its statutory activity in matters concerning the legal interests of other persons, if it took part in the administrative proceedings. And the last one, it is any other entity to which the laws grant the right to lodge a complaint. I don't want to stop along a lot of when I will talk about the last category, because when we look at the law, it occurs that actually they represent their legal interests. So they are close to the category number one, anyone who has a legal interest in it, while public prosecutor or social organizations, and they are different kind of interests. So from the beginning of the existence of the administrative court in Poland, so it is more or less 100 years ago, the basis of procedural capacity was a legal interest. But due to the narrow scope of the court's cognition in the regulation of the interwar period, parties to administrative proceedings and before the administrative court were equated. But it changed. It changed in 1990. It changed because at that time there was a significant expansion of the scope of administrative court's cognition. Previously, the concept of a party to administrative proceedings was used, but in a view of the expansion of the cognition, it became insufficient. So it was not enough. And at this point, it is necessary to point out the differences in terms of proving a legal interest occurring in administrative proceedings and proceedings before an administrative court. While the administrative proceedings, the interest has to be delivered primarily from the provisions of substantive law. In administrative court proceedings, it can also be based on the provision of procedural or other kinds of law, not only substantive law. In jurisprudence, legal interest is derived from the law, so substantive or systemic or procedural. Substantive law is, of course, predominant. And to generalize, if rights or obligations arise for a person from the provisions of substantive law, then she or he has the status of a party to the administrative proceedings, and an administrative decision applies to him or her, and that's why this person can seek protection before an administrative court. Whether a subject is a party to administrative proceedings is not determined by a subjective attitude, by will alone, but by the circumstance of whether there is a provision of substantive law allowing the subject's interest to qualify as a legal interest. That's why it is important to distinguish the legal interest from factual interest, which is not given protection before the administrative court. And participation in administrative court proceedings is based on a legal standing. And this, in turn, is based on a legal construction of violation of a legal interest or right. The scope of jurisdiction of administrative court, which includes challenging the activity of public administration in various legal forms, results in the derivation of a legal interest requiring complex processes of interpretation of the law. And it is relatively straightforward to demonstrate the legal interest in complaints against administrative decisions or some other individual administrative activities, like in Polish law, individual tax interpretation. In this case, we can clearly limit to the substantive law regulations, assuming that the content of the legal interest will be a public subjective right. In Polish administrative court proceedings, the legislator has clearly defined the scope of the control exercised by the administrative court. It includes complaints against administrative decisions, central decisions, tax interpretation, and so on. Among the enumerated acts, there are also other acts or acts of public administration, undefined, which are accompanied by difficulties of interpretation. And maybe this part is not very common exercise, but for sure it's much more interested from the legal point of view than in case of administrative decision, when it is let's say, very easy to detect the legal interest, and as a consequence, it is easy to find the protection before administrative court. Moving to social organization, I would like to say 2 words about public prosecutor, ombudsman, and ombudsman for children. For sure, their interest in participation before administrative court differs from the persons that are mentioned in category number 1. So first of all, both public prosecutor and ombudsman can participate in administrative proceedings, and when they participate in such proceedings, they also can complain before the administrative court. And first, they have to before use the administrative remedies, But public prosecutor and ombudsmans can also go directly to the administrative court when they, even if they haven't participated in administrative procedure. So the question arises, what is the interest that they are protecting? It is a kind of legal interest, or maybe other interests that are that arose from the legal regulation. And now social organization, their legal position is much more interesting and much more complicated, developed comparing to the situation of the persons I described before, because the most typical case, if it was a party to administrative proceedings, then its standing to bring an action is based on having a legal interest. However, it seems more common that organization will be involved in administrative proceedings as a party. The position can be defended that it will represent a social interest rather than a legal interest in these proceedings. In such a case, it will retain its active right to action before administrative courts. And the rules of access of environmental organization to administrative proceedings are regulated in detail by the Code of Administrative Procedure and acts regarding EIA procedure. It is a procedure connected with environmental impact assessment. And this position of environmental organizations are different comparing to social organization, because environmental organization, when we are talking about the procedure with a public participation in the meaning of Directive 2003 and 35 is I can say also it is privileged because environmental organization can participate in administrative procedure only because it is environmental organization, and it can challenge the decision to the second instance in public proceeding, and environmental organization can go directly to the administrative court. Directly, I mean that environmental organization doesn't have to participate in administrative procedure, but at the same time, when the procedure is ending with the final decision, it can go to the court. And last year, environmental organization gained the right to complain about investment decision. Still, we are talking about environmental field. This applies only to those decisions that were preceded by an environmental decision issued in a procedure with public participation. The extension of the complaint rights of environmental organization resulted from the need to bring Polish domestic law in line with the EU law and also with Aarhus Convention law. From the perspective of my article, the question arises, what interest does it represent, and what is the relationship of the interest in relation to other interests at stake in the case, especially when we are talking about environmental organization and social organization. And One interesting fact that it arises from the Polish procedure before administrative court. Coming back to social organization. A social organization that didn't participate in administrative proceedings may also apply to participate as a participant in the case concerns the scope of statutory activities. But if the social organization didn't take part in at the stage of administrative procedure, it cannot go to the church and complain about the final decision, but it can join when, let's say, somebody who has legal interest started the procedure before administrative court. The question is why this social organization can't go directly to the court and ask for protection of what kind of interest? I would like to have a question mark at this idea. And finally, when I will do my research, first of all, it is important to analyze the regulation regarding Polish procedure before administrative courts. Then it is also important to look at the constitutional provisions. Then we have the law of administrative procedure. Yes, our code is from 1960. And what about technical issues? So the main research is a dogmatic legal analysis, and the current legal state consists of solutions developed for about 100 years. I said at the beginning that our procedure before administrative court, it is about 100 years old, which is what is kind of tricky because during the Soviet time we didn't have administrative courts any, but our administrative courts are celebrating because it is exactly in this year 2002 when 2022 when they are celebrating 100 years of existence. So commonly we say in that in general way that the procedure is 100 years old. And the use of legal and historical method will allow to answer the question of the changes that have occurred over time with regard to the subjective side. Related to this issue is the question of whether, and if so, how the changes relating to the subject of standing were correlated with the types of interest to be protected in the administrative courts. And thank you for your attention. I know that the subject chosen is quite difficult, but I think that you can find it interesting.
Sure, yeah, we found it interesting, at least me, and thank you very much for choosing this topic, as no court procedure can be imagined without participants, without parties, and especially this kind of non-symmetric court procedures where one participant should attack the other one's decision. The administrative court procedures require a detailed regulation and a reasonable regulation of the participating rights. So thank you very much for your topic, and thank you for your presentation, Agata, and thank you for all of yours presentation. From here, I say thank you to Gábor Hulkó, who sent his video presentation with his voice and important information about the, as he called, the judicial activism of the European Court of European Union. I think we made a major start in our topics, all of us, and this start will help us to reach the first milestone in our project, in our research group's work by the middle of September. I think we will meet each other at the end of August. I will write you possible data and time limits or times for starting our next meeting, and I wish you good holidays and sunny summer for the rest.
Yeah, thank you.
Much.
Thank you very much.
Thank you very much. Goodbye.
And thank you for the organizers as well. Thank you.
Yes.
Bye.
Thank
Bye.
you. Bye bye.